Good morning, Your Honors. May it please the Court. This Court has long warned that the danger with vague laws is that they invite arbitrary and discriminatory enforcement. It suggests that this is the case we have here, where the Board of Funeral Directors, the Board of Registration of Funeral Directors and Embalmers relied upon a particular provision of the Code of Conduct as a pretext to punish Mr. Schoeller for speech that it otherwise found distasteful. And there's no dispute that the Board of Registration has properly can regulate the embalming profession, and in some instances may even limit embalmer speech. But to the extent that they're allowed to do so, they must do so with narrow specificity. And I'd suggest that given all of the potential legitimate interests that are raised in my sister's brief of reasons to possibly limit Mr. Schoeller's speech, the Code of Conduct and the provisions of the Code that were used to discipline Mr. Schoeller have not been sufficiently tailored under any standard of review to satisfy those interests.
Let me turn. Let's put aside 3.13, Section 7. The Board, as best as I can read their decision, seemed to have a separate ground, which was that his was unprofessional conduct that undermined the public confidence in the profession and the integrity of the profession. Yes. Do you agree that even in the absence of a regulation or a code of conduct, they may discipline if they were to make that finding?
Yes.
Okay. And was, when he was testifying, he admitted, I think, that if he had known that it was to be recorded or published, he wouldn't have used those words. Correct. Is that not enough to say that it was conduct that even he recognizes in terms of speaking to the press in a manner that arguably was careless of him to not recognize would be on the record, undermine public confidence?
Well, I think we'd have to, if we had taken out the section, 3.137 and not looked at that and not treated that as any sort of basis for it, it would make a difference as far as what additional findings the Board would find about his speech. And I say it in this way. 3.137 seems to be almost strict liability, at least on its face. You cannot comment on a deceased person at all. If instead we weren't treating that provision, or at least not looking at under that provision, we're looking at under the theory of him undermining the reputation of the embalming profession, I think they'd have to look at the other circumstances of his speech. And what he was credited by the hearing examiner, his testimony was credited. And what he indicated was he did not understand that that was part of the interview. When he was speaking about those things, he thought that was just part of a social conversation. And to that end, if the Board was to act against someone for only speaking in a social conversation using a word choice that they disagreed with, one, I would suggest that would be quite significant in terms of justifying the sanction that would be appropriate. I'd say that's a fairly minor violation. I don't think that's one that would require a major sanction at all if he simply thought he was having a private conversation. If he had intentionally gone out and, for example, had he written this article, I think that would be a different story. Had he written this article, and this entire article was sort of his creative product, and this is how he chose to express his views of embalming and present it to the public, then he'd be fully responsible for this end product, and I think that he might be in more serious trouble with the Board for that. But if he's been credited that those statements he didn't realize were being published, didn't think was part of the article, and was just a conversation. And to that end,
well, it's a conversation with a reporter in the context of an interview, which the reporter was going to write for the Boston Phoenix.
I think he didn't understand that those statements were going to be part of the interview. The way what happened was the interview occurred over 2 days. The first day of the interview occurred at his store, and it was supposed to be about the store he was opening. And he indicated that during that interview, it had all the qualities of a typical interview. She's asking him questions. She's writing down his answers. He understands this is for the newspaper. The second day, they went to a restaurant. And it was only midway through the evening that he had realized that it was being recorded. And that's when he had a conversation with the reporter indicating, oh, I didn't realize that. But he did not. He would thought they were speaking casually. He engages in a profession that people ask questions about. They find it interesting and fascinating. He thought this was an article about a store. That's what this article was originally designed to be. Come and interview him about a store he's opening. He just thought this was incidental conversation they were having.
Well, let's assume it was an incidental conversation, and it was a specific conversation about a particular body that had been entrusted to his care for embalming purposes. Would you say that's all right?
I'd say that's all right because what's very important here is whether or not he's giving out any confidential information or privileged information in doing so. This was a position
Oh,
that...
I mean, look, I'm looking
Sorry,
at his oath.
I'm sorry. Let me. I'm not sure if you understand. I think what Justice Cordy is asking is if he had referred to a particular body, if he had spoken about, I just saw the body of John Smith and was describing that body, are you saying that would be okay?
I think that would be problematic because I believe if you're giving that kind of detail, you'd be giving information that would constitute privileged or confidential information. There's certain private details about this. There's a level of abstraction, which I'd suggest you are allowed to talk about practices that you've engaged in. And that was something that was litigated early on. I filed a motion to dismiss early on alleging that a limiting construction should be applied to particularly 3.137. And that is, if the first part of that paragraph talks about confidential information about the deceased or the family members or the members of the household of the deceased. And then it concludes with saying you should not comment on a person entrusted, the deceased person entrusted to your care. And I'd suggest that you read that in conjunction. What it says is you can't give out any confidential information. You may learn many private personal details about a person's life in the embalming process or simply in the preparation of a body for burial. We discussed that, and the board agreed that they were not advancing any claim, and that's written specifically. The hearing examiner explicitly noted that in her decision.
But there really are two pieces to 3.137. One is giving out confidential or private information about any member of the household or family. Mm-hmm. And another is the comment on the condition of any dead human body entrusted to his or her care. Mm-hmm. Those are different.
They are. This is why we had to look beyond simply this code and look at what was happening in the profession and what they're doing in the profession to see what meaning was given to that. And I think what's quite significant is I've reproduced the significant portion of Investigator Bresnahan's testimony in the appendix. And when questioned about this, because this was the basis for my cross-examination of him, is this really a rule that's enforced? Is this in fact a rule that the board enforces against embalmers, that they may never comment on deceased persons? And they said unequivocally, no, it's not true. When asked, I asked explicitly, does the code categorically prohibit an embalmer from commenting on a deceased person entrusted into an embalmer's care? And he stated it did not. That's on 131 of the appendix where he answers that. I then go through and submit it, and you have the exhibits, countless exhibits I submitted through the hearing, including trade journal articles with various exemplars of types of statements that I'd suggest in terms of content are identical to what Mr. Schoeller had stated. One of those articles discusses details about the family members of the deceased, not just the deceased, the details about the family members, what they're witnessing, what they're going through at the time of the burial. We brought in articles that talked about very, very explicit details about an embalming process of someone who was a victim of a fire. And most significantly, I suggest, was an article that, in my opinion, had quite salacious qualities that was titled, "Please Take That Thing Off My Son's Face, Part 2. There's an explicit description of a disfiguring tumor on a young man's face that the writer describes as being the most grotesque things he'd ever seen in his life. I put these in because this is what's done in the profession, and they are allowed to talk about it. And the position we maintained is you are allowed to comment on it. The board accepts that one is allowed to comment on a deceased person. This is part of what happens in trade journals. This is part of what happens in education. This is simply what people are allowed to talk about. I'd suggest even to the press, describe what happens in embalming. And he approved every one of these articles, said every one of these articles was just fine. And I think that's quite significant because I accept the language is quite hard in 3.137 for me. I mean, if you read it literally, you cannot comment on a deceased person trusted to your care. If you read it literally, Mr. Schoeller has no defense. I have no leg to stand on. I wouldn't dispute that. But that's not how the profession runs. That's not what they enforce. They say everything he said, they approve essentially the content of what he said in all the trade journal articles that they write. They said, oh, that's all fine. And that they instead impose is this professional language standard. And that is completely separate than the standard for commenting on a person who's entrusted to your care. If they want to enforce some standard that says you should use professional language when speaking about embalming, if you're going to talk to your wife when you go home or when you're going to go talk to a newspaper, and you have to use professional language. I'm not necessarily suggesting that isn't perhaps a legitimate interest. I'm not conceding that point. But to the extent that it is, then they should be drafting a statute that limits that. And I put in evidence, and it's both in my addendum, the current version of an Arizona statute, but I also admitted by way of an exhibit, I believe an older version of the statute that was at least used by way of cross-examination with Investigator Bresnahan. And that statute I suggest you can look at. That statute, I think, deals with a lot of the concerns they're suggesting, and it deals with it quite well. If you're concerned about someone making a comment that's going to offend the family of a deceased, then make a rule that limits it. And Arizona has a rule that deals with that. Don't make unnecessary comments to the family, a grieving family, about the deceased. Don't disclose unnecessary details about the embalming process to the family of a deceased. Do not disclose confidential information you've learned in the embalming process. And it explicitly goes through the types of things you can and can't say. And if the board wants to regulate these things, if the board wants to further the interests that they've suggested in their brief, look at the Arizona statute or perhaps other codes. I'm not suggesting that's exhaustive of statutes that permissibly have some limits on speech, but it gives guidance. And that's what's required in the First Amendment.
Now, you say the board interpreted 3.137 to exclude professional statements.
Yes.
I don't read the board's. I know that that's what the expert testified to, but I don't read the board's findings to say that. Is your view that the board findings make that exclusion? I don't see it in their. I don't see it in their decision. Well,
I'd suggest that the board's findings are to the extent that there's any evidence to support the board's conclusion, then it would be based on the standards advanced by Investigator Bresnahan. Other than Investigator Bresnahan, I'd suggest that there is no evidence that was in the record before the hearing examiner to support the conclusions that they've reached. It's all based on their acceptance of him as an expert and him advancing the standard of care in the industry and what standard they should be applying to interpret it. There was no other evidence whatsoever. If anything, there was contrary evidence by Mr. Schoeller that is not the practice in the profession, that he's been practicing for many years in multiple jurisdictions, and that is not the practice. That is not what he is told.
Now, so, the board rejected your analysis in terms of the interpretation of 3.137, saying that, no, this idea that it protects only discussions about a particular body is not supported by the language of it. What do we do when the board, who is responsible for this and responsible for interpreting its regulations, says that's not an appropriate interpretation of this regulation?
Well, I'm sorry, are you suggesting that they're not suggesting that the investigator's interpretation is correct?
No. Well, I mean, I'm suggesting that I don't see anything in their analysis of 3.137. I know that the AG says it's there, but I don't find it there. As far as I can tell, they said your client made a comment on a body, and that's it. I don't see anything. I see a discussion of unprofessional conduct as to its second claim, the one that I spoke of earlier, but I don't see anything in terms of its interpretation of this comment that limits this comment to unprofessional comments.
Well, in that sense, then, if you accept that interpretation, then I think that still supports my claims of vagueness and, or at least perhaps even strengthens my claim of overbreadth. If it's going to be adopted literally.
Sorry, I just didn't. You talked very fast. What did you? Vagueness or
overbreadth? I think that's where the overbreadth would really.
Well, it's not vague. It's perfectly clear. If you comment on the human body, that's violation.
Correct. Although, admittedly, I have had major difficulty in understanding how then the board can completely approve of some of the trade journal articles, which in my mind, content-wise, are indistinguishable, and suggest that it's okay and have no qualms with it. But I understand the point.
I'm sorry, you said the board. Are you from the board's expert or the board?
The board's expert. The board's
okay.
expert, rather. Well, then that would raise real overbreadth questions. If they're allowed, if it's read literally then, and then it's a permissible standard, then it prohibits even disclosures permitted by law. Then should be read literally. You may never disclose any information about a deceased person trusted to your care. And if you're interpreting the board decision as interpreting that standard literally, then that is, I suggest, a very overbroad statute. Then that would mean that when the embalmers follow, and I apologize, I don't have the page number of my brief, but I cite numerous other sections of the Code of Conduct where embalmers are required to make disclosures about the condition of a person entrusted to their care. If you were to read that condition literally, and the board's finding that statement should be applied literally, then an embalmer cannot comply with the other requirements of the law. He has to make reports, to various state agencies or to family members about certain things. And I'd also suggest that intrudes on Mr. Schoeller's First Amendment freedoms otherwise. I think a categorical rule preventing him from talking about his occupation does not satisfy constitutional requirements. The public has a legitimate interest in knowing what happens. I mean, there's a famous TV series, 6 Feet Under, that's been on HBO for nearly 10 years that deals with embalming. It's a subject matter it's a matter of entertainment. People are interested in it. People have a right to know what happens to their deceased family members when they're brought into a funeral home. People have a right to know what happens in this process. And so therefore his comments were subject of legitimate public concern. And if it's going to be read so literally, then I'd suggest that it's a very overbroad statute and it should fail on those grounds.
All right, thank you, sir.
Thank you, Your Honor.
Good morning, Your Honors, and may it please the Court. In In re Cobb, this Court held in the attorney discipline context that the state may regulate the speech of licensed professionals under a less demanding standard than that established for other types of speech. This case, therefore, does not require the Court to break any new ground. Like attorneys, funeral practitioners are professionals who, in exchange for the privileges of a license, have sworn to conduct themselves in accordance with the ethical requirements established by the disciplinary board. Thus, while Mr. Schoeller did not check his First Amendment rights at the door when he obtained his license, his asserted interest in the speech at issue must be weighed against the board's interest in regulating the funeral services industry and in protecting the public welfare.
What if he talked about this same very subject but used more professional language? Talked about the challenges of embalming a child who's been through certain procedures, or the challenge of embalming persons that are particularly heavy. I mean, what if he just didn't use the obviously offensive language that he used, but still talked about the same subject in this context?
I think that would be a much harder case for the board, Your Honor. The board would have to show that it has an interest in preventing legitimate conveyance of factual information to the public, but that's not what occurred in this case.
But what's the standard, though? I mean, how is he supposed to know where that line is drawn?
The standard, Your Honor, comes from the common understanding and knowledge of the members of the profession. When professionals are not operating in a vacuum, they have the benefit of the guidance of the law of the profession. This court has held so repeatedly, as have other courts in other jurisdictions. And Bresnahan testified that with respect to funeral practitioners specifically, you are taught how to conduct yourself and how to speak appropriately through your schooling, your training, and the apprenticeship that you're required to undergo before you obtain a license.
I think you said something like you know it when you see it. But maybe
I'm sorry, Your Honor?
I'm sorry. I recall something like you know it when you see it, kind of.
That's what Bresnahan testified, Your Honor. But he also testified elsewhere that you are taught these ethical standards, how to communicate appropriately through the training that you're required to.
Now, Bresnahan is not the findings of the board. The board's findings are the findings of the board. Do you agree?
I agree, Your Honor.
Do you see anywhere on page 23 or 24 of the record when they're discussing the violation of 3.137 that they are limiting that provision to unprofessional comment?
I agree with you, Your Honor, that the decision doesn't do so explicitly. However, it's implied because on pages 23 to 24, the board discusses whether the conduct violates the 313 sub 7, but then it goes on to discuss whether that can actually constitute grounds for discipline. And on pages 24 and 25, it goes on to discuss whether those comments can constitute unprofessional conduct. And
then that raises a different issue. I had thought 24 and 25 was raising a second and independent claim, which is that it was undermining public confidence in the profession and the integrity of profession. Are you telling me that I'm wrong and that the entirety of this is based on Section 7?
Absolutely not, Your Honor. I think the discussion on pages 24 and 25 can be read both ways. I want to note that violation of there was a separate count in the order to show cause alleging that Mr. Schoeller had committed conduct that undermines the integrity of the profession, and that is a separate count. So I agree with you that the discussion on pages 24 and 25 also relate to that separate count. And this court held in Sugarman versus Board of Registration of Medicine that conduct that undermines the integrity of the profession is an independently sufficient basis for the imposition of discipline. So the board's decision in this case can be upheld either under what I argue is the implied limiting construction of the regulation, or under the separate count for conduct that undermines the integrity of the profession.
So then are you are you conceding that 3.137 would be overbroad if interpreted to prohibit any comment on the condition of any dead body entrusted to a person's care?
I think that would be a very difficult case for the board, Your Honor. It would have to put forth some justification that it has an interest in prohibiting all comment, including
Are you so contending? Because that's what the board found.
I'm sorry, am I so contending?
I mean, that's what the board found. The board did not limit it. The board just said he made a comment on it. He violated Section 7.
And again, I would argue that it then went on to discuss whether it has the authority to discipline him by assessing whether the comments constituted unprofessional conduct.
And are you saying that if it had not done that, it would be overbroad in having such a prohibition?
I don't know if it would be overbroad, Your Honor. The overbreadth doctrine requires that there be a factual record developed as to substantial overbreadth. There is no – Mr. Schoeller has not developed any record in this case.
Well, hasn't he had discussions about all the public – about all the times in which a person would be discussing the embalming profession, whether it be to discuss it with the medical examiner, with teaching, with public trade journals, public education?
He has, Your Honor, but under the overbreadth doctrine, he has the burden of showing, providing evidence that the regulation has chilled a substantial amount of protected speech, and he's provided no evidence in that respect. I agree with you, however, that if the regulation is read literally, that in the First Amendment balancing context, the board would have a much more difficult time of showing that it has a substantial interest in chilling the legitimate conveyance of factual information, which is what we contend is contained in the trade articles that Mr. Schoeller put into the evidence.
Now, the board did not make any findings as to whether or not Mr. Schoeller understood that he was speaking for the record. I gather because it didn't think it mattered.
I think the board did accept his testimony that he did not know he was being recorded. However, he did know that this person was a reporter, that she was writing an article about him. He's made no contention, put in no evidence that there was ever any understanding that this was completely off the record. So I don't think that his characterization of this conversation as private is an accurate reflection of the
If he had
evidence.
made the same comment to a friend, would that be the subject of discipline, or is there something about the public nature of speaking to a newspaper reporter that changes the nature of it?
It certainly figures into the balancing analysis, the fact that his comments were so public. Theoretically, I suppose an embalmer could be disciplined for private speech, but as a practical matter, that type of case is very unlikely to arise because it has to be brought to the board's attention in some way. But I don't think legally it necessarily matters, and I would point to the first part of the regulation prohibiting the release of confidential information, and that, even if that's done in private, I don't think there would be any First Amendment concerns to impose discipline.
But you're not claiming that there was any release of confidential information here, are you?
No, I'm not, and I'm also I also dispute Mr. Schoeller's contention that this conversation was a purely private conversation.
Okay, well, but could we not need to remand it, to the board to at least determine whether or not he was speaking on the record or off the record, or whether he understood he was speaking on the record or off the record?
No, I don't think you do, Your Honor. And again, there's no evidence, he presented no evidence that he said this is off the record, and also he admits that after he realized he was being recorded, he did not object to her going ahead and publishing the article. That's contained on page 6 of his brief, and it's also in the record. So I don't think a remand is necessary in that regard. And if I may just turn to the board's interest in this regulation, the Funeral Ethics Association, and Mr. Schoeller has put the code of conduct into the record. It recognizes that funeral practitioners serve their fellow citizens during one of the most trying times that a human being can experience. The code, therefore, expressly requires that funeral directors be empathetic, that they have an understanding of the psychology of grief and the mourning process, and to always remember that the body that's been entrusted to them represents the cherished remains of someone who in life held the love and esteem of a family and friends. And in furtherance of these ethical standards, the Code of Conduct expressly addresses statements to the press. And this is at the record appendix on page 87. The code states that when a funeral director is speaking to the public, he has the obligation to exercise the, quote, utmost discretion, because it recognizes that harm can be done by trying to make headlines. And so sensitivity, dignity, respect are at the very heart of this profession. And indeed, this is an industry that prohibits the use of profane, indecent, or obscene language in the mere presence of a dead body. And that's contained in the statute itself, not in the regulations at General Laws, Chapter 112, Section 84, and numerous other states have similar provisions. On the other side of the coin, I would submit that Schoeller has not identified any interest that he has in making unprofessional comments, and particularly the type of callous and vulgar comments that he made in this case. If his comments are okay, then any funeral director or embalmer in the state would have license to go out and describe the types of bodies that he finds nasty or that he finds amusing. And if I'm someone whose loved one has just died, my mother or father just died, the last thing I would want is to feel as though the funeral home to which I've entrusted my loved one's remains is mocking the condition of the body.
I mean, in fairness, when he was discussing the baby, wasn't he essentially speaking of the art? I mean, wasn't he speaking of taking pride in the art of the embalming that he did so that that child could be presented at the funeral in a decent form as opposed to the condition that the child was found by him?
I think that passage taken in isolation is a little less problematic. I would still argue that the description of a baby as a bearskin rug shows a distinct lack of empathy for the parents of that child, but that passage still has to be read in the context of the entire article, and no reasonable professional or even a lay person could argue that it's professional to say that you really hate embalming fat people because they're nasty, to compare the condition of the body
say they were
to
nasty. He described some of the product of when you begin to embalm.
He describes the process as nasty, you're correct, Your Honor, but he also compares the condition of the body to the fat chunks on his dinner on chicken satay. He says his friends find it amusing that he farts out dead people raw. I mean, under no reasonable characterization can these statements be found to be respectful to the deceased, which is the fundamental ethical principle that underlies this industry. And I want to emphasize that people do not have a choice when their loved one dies. This is a specialized industry. Lay people are not trained in funeralization or disposition of the remains of the deceased, and they are dependent on this industry. And this is why it's imperative that its reputation that shows dignity and sensitivity and respect to the deceased is maintained. And again, this court held in the Sugarman case that boards have very broad discretion to protect the image of a profession that is an independently sufficient ground for the imposition of discipline. And so I would argue that this case can either be upheld under the regulation or under the separate count for conduct undermining the integrity of the profession.
Now, the board had asked the matter to be remanded so it can better explain its sanction. I wasn't quite sure what that was about.
Yeah, just to follow up on that, does that mean the board wants to do the same sanction but justify it better, or does it want to reconsider the sanction itself?
I think the board on remand should reconsider the sanction itself, and whatever sanction it chooses to impose, it just needs to provide better reasoning in its written decision. We acknowledge that the decision as written does not contain sufficient reasoning for the court to engage in judicial.
But the question we're really asking is, are you saying, are you agreeing it's too harsh and you want a chance to do something which you think is a bit less, or do you simply want a chance to provide greater justification for the same sanction?
I personally can't say, Your Honor. There's been some turnover at the board, so the board certainly would be free on remand to impose a lesser sanction. I just wanted to point out that even in Arizona, which Mr. Schoeller holds up as the model of what the Massachusetts rule should be, even Arizona recognizes that licensees shall not engage in any conduct which causes or result in disrespect for the deceased person. And then it specifically goes on to address speech, and it says, a licensee shall not make statements nor engage in activities which foreseeably could result in exposing the remains to unnecessary indignity. And I would argue that Schoeller's statements fall within the scope of that rule, and so he could be disciplined in Arizona. That is the standard of care in the overall industry.
Does it have to be identifiable in any way?
I'm sorry, Your Honor?
You're talking about this in, any remains at any time, anywhere, or identifiable ones that somehow, I just don't know how broad this is supposed to go.
It wouldn't have to be the remains of a specific person. That would be covered by the first part of the regulation.
Right, so, somebody then who is licensed could make no generic kinds of comments, so long as it was about a deceased person who had been embalmed?
If it was in the same type of tone
Right.
that was used, then yes, Your Honor. It could.
Counsel, thank you.
Thank you.